High Court, it would essentially be prejudicial to, so to speak, public interest. Again, I'm not sure, again, if you could explain further what was the reasoning behind your decision so that I can understand your judicial philosophy.
Yes, my judicial philosophy.
Yeah, my lady, I think you're...
Thank you. My judicial philosophy in this was also informed by justice. As you mentioned, these were the Anglo-leasing contracts that were entered for an entity in the UK to come and provide security systems. There are many contracts like that. The contracts were running into billions of money. The contracts were signed, but when the NAC government, Kibaki government, came in the office, I think the Ministry of Finance questioned the validity of these contracts, wanted to evaluate them and see whether there is value for money, and contracted PwC, an audit firm, to audit these contracts. These bodies, Midland Finance, which was supposed to finance the contract, came to court to say you cannot audit these contracts. And the judge of the High Court agreed that these contracts cannot be audited. So when the appeal came before us, we looked at it and said, under the rules, under the Constitution, accountability, value for money, what is wrong in evaluating a project? Even if I have signed a contract that I'm going to build a house here with the contractor, and then I decide, wait a minute, I relied on a QS, can I have another QS look at it? What is wrong with that? And that was a decision in that matter. We said PwC could look at the contract and give an opinion whether there was value for money.
And finally, when it comes to your sample writings, I notice again this decision of Supernova Properties Limited, where the Mombasa court actually, they had lost the title. Now the party was claiming that it is their title, validly issued as far as you are concerned, but you looked at the matter differently and restored the Justice Tower to the public and the litigants generally, taking into account again the issue of the public interest. Now, how do you balance out the proprietary rights of an individual vis-a-vis those of the public when it comes to ownership to property?
Yes, thank you. That was a very difficult decision, and for the sake of the commissioners, this was a dispute of the land where the Mombasa Law Courts, the Justice Tower, is constructed. This land, I think, I don't know whether accidentally or was allocated, was grabbed. And the people who were allocated were claiming it, that it is our private property because we own it, we have the title, we are registered, and therefore we want to examine the proprietary rights like Commissioner Macharia is raising. First of all, before the rights of the judiciary were appropriated, judiciary was not consulted, and judiciary was in possession, rendering services to Kenyans. The arguments by these people who had been allocated the land were very strong. They are saying, look, we have the title. So the judgment is profound in the sense that it says, if a party is in occupation of a land, like judiciary was, and that land has to be appropriated by whoever, that body must be informed, and that body must give its consent. There was no consent by the judiciary. So whoever allocated the land, that was, I think, the registrar of lands or commissioner of lands, whoever it is, to these ROTs, it was wrongly allocated. If they suffered any damages as a result of that allocation, then I think their rights belong to civil matter. Is not, they had no right over that property. Okay. The Justice Tower is there. The Justice Tower is the temple of justice where Kenyans go to seek justice. And that's what we send in the judgment.
Okay, thank you. Now, let me come to your ears in, say, basically working both as an advocate and as a judge, because sometimes it's what you've done that will speak mainly about who you are. Because in an interview, anybody can say anything, but we are more informed by somebody's past. And now, I remember you actually when I started practicing, and the Mother Koome I knew is the one who was, always out there with the Law Society, fighting, these issues. The second liberation, the issue of political rights and detainees and all that. Even demonstrations. In fact, that's the Mother Koome I remember.
Yes.
Before she became a judge. Now, I would want to understand. What was motivating you into all this? Because there are many of us who are in private practice who prefer that this is somebody else's problem. I would want to understand for you, what exactly is it that was driving you into all this?
Thank you, Commissioner Macharia. I think what was driving me was I was seeking justice. I was representing the public. Those were public interest matters. You remember during the one-party rule, the Kano government was closing in to take over all the independent institutions. The judiciary was part of the executive. Maendeleo ya Wanawake, the major women's organization, had been appropriated. It was Kano Maendeleo ya Wanawake. The COTU, the workers' movement, the Kano government was trying to take the church, the NCCK, and the Catholic Church, but they were resisting vehemently. The Moi government was also trying to take the Law Society. In fact, at the point at which I became an activist and a campaigner for the constitutional review, independence of the judiciary, is when there was an attempt to influence who becomes the chair of LSK. So I was driven by public interest, the search for an independent judiciary, because I was a young lawyer and I could see, unless we have an independent judiciary, then I have no future as a lawyer, even if I have my own practice. So that's why I joined with other lawyers, and we started the campaign of review the Constitution, review the laws, repeal Section 2A. Section 2A was repealed, but the institutions of one party still remained. We campaigned, we had the 1997 IPPG, partial reforms that even introduced some little affirmative action in nominated seats, so that nominated seats and to take into account gender parity. It never happened. I remember myself on behalf of FINDA with Jean Kamau suing Moi the president then, for not complying with constitutional amendment that required gender parity. But of course, the case was struck out because you know it was said we could not sue the president who was in office. He was immune from civil and criminal liability. So this is work we did at the Law Society. FIDA also realizing my clients whom I was representing, because the firm where I worked when I was first admitted as an advocate, I was a junior associate, so the partners would not take cases for women. They were time consuming. The women had no money to pay, and they said these women they require a lot of emotional support. They cannot render them a shoulder to lean on. So those cases were thrown to me. And as I came to court, I saw how difficult it was to convince judges using 1882 Married Women's Property Act to say this woman who has been married for 20 years or more, or even 10, has been thrown out of her matrimonial home. She needs a share of the matrimonial home. She needs maintenance, children, all that. I saw how difficult it was. So that's why I joined FINDA, so that we could solidify our voices and seek law reform that took care of families. Because families are important. Families are the foundation of the society. So I've always been driven by the quest for justice. And whatever work I do is defined by the situation in which I am in. Whatever God puts in my hand, I try to do better. I try to be innovative. I try to achieve the very best from the circumstances. So when I was at FINDA, I was a firebrand because the work required me to be a firebrand.
Yeah, which is where I'm coming to actually, FIDA, because that's the other mother Koome that I knew of before the judge. Why gender equality and children? Because again, the mother Koome I knew in private practice was so firebrand, apart from, of course, the political issues on women rights and the children. I would want to understand what exactly, because this seems to have been your life even up to date, you know. I'm not faulting. I'm actually
Yes, yes.
it's something I like.
Yes.
You know, there's nothing negative about it, and it's something I'm also passionate about. That's why. But I need to understand why.
Yes, I think I'm an all-round lawyer. Even when I was practicing, I was a conveyancer to boot. By the way, I was representing some corporate clients who were actually able to pay my bills. I practiced in the Mirimani commercial court. I practiced land law. I was an all-rounder. But what pricked my conscience was the violation of women's rights and children's rights. And this was a threat to the family. And this was a threat to the country. You cannot have a country where families are acting. Because if you're okay at home, everything is working at home, even when you go to school, you will excel. Even when you go to do business, you will excel. But if there is skirmishes at home, there is no peace at home, there is no harmony at home, then you cannot thrive anywhere. I perceived women's rights and children's rights to be central to the family because they anchor the family. And I realized there is a big gap. For women, there were no laws completely. You know the raft of laws that have been enacted from the matrimonial properties, protection against domestic violence, matrimonial act, all those acts that have come were not there. We were relying on those English-owned registrations, and we used them, argued cases all the way to the Court of Appeal, and they became precedents to inform the future review of the laws. And children as well. Children's laws were scattered in 17 statutes before we came up with the Children Act. And children are vulnerable because they are young. They don't speak for themselves. Somebody needs to speak for themselves. to speak for them. Today, we have this Constitution 2010, which is very progressive, but the Children Act has not even been reviewed and realigned with the Constitution 2010, but I'm proud to say the committee that was put together by the NCAJ, which is a body of this JSC, has worked on a draft children's bill, which is currently at the floor of Parliament for consideration.
Okay.
Yes.
You are involved in Echaria versus Echaria?
Yes, I was. Echaria was, Priscilla Echaria was my client.
Yes.
Yes.
Now,
and it went all the way to the Court of Appeal.
Yes, I recall. And that's
Yes.
why I'm saying I remember that again when in a private practice.
Yes.
Now, what is your take home in that matter? Because, of course, it's one of the major cases that have been used again and again when it comes to issue of a matrimonial property.
Yes, I think the Constitution and the Matrimonial Properties Act now have settled the issue completely. So we do not have to navigate the 1882 Married Women's Property Act, English registration, and precedents from outside the country. We are good with the law as it is.
Yeah.
It defines what is matrimonial property, what is direct and indirect contribution, because the ratio decidenda in Echaria case was a contribution, especially indirect contribution.
Yeah.
When a woman is married, say she is a housewife, but she is looking after children, she is doing household work at home, looking after the husband, supporting the husband and the children. When it comes to the division of the matrimonial property, what value can you give to those indirect contributions? So I think the law now is clear. So we won't go into the merits because those are live disputes.
Yeah.
Yes.
Which brings me now to the question. Of course, if you become our Chief Justice, you are Chief Justice of all. But this issue of gender equality and children's rights, we seem to keep throwing it to the back burner. High-sounding statements, political statements and all that, but we don't seem to get it right. Now I'm wondering, as the leader of, the one to guide the jurisprudence development at the Supreme Court, the apex court, and generally also cascading it, within the entire judiciary, what steps would you take as our Chief Justice to ensure that, we're able to also use the law to resolve this issue? And I say this because we must accept that countries that have done very well when it comes to gender equality, they are doing very well, but we seem here to keep, struggling and fighting over it as if it's a bad thing. It's like we have to fight over it. And when I say gender equality, both ways, because again, we also don't want it to now move against men. But what would you do finally, if you're given that opportunity to make sure that you're able to run with this agenda and we sort it out?
Thank you. I think the law is established, and that's the first step. But as we know, laws are always not the panacea of all the problems that we have. We have a big problem in this country of creating awareness, informing people that this is the law. For instance, I wouldn't understand why somebody in 2021 would tell a daughter of a deceased person that she is not entitled to inherit the estate of the father. It is there in the Constitution, it's there in the law of succession. So we have our own cultural beliefs, cultural practices about what we perceive a woman to be, but this is all a matter of education. We will get there. The cream will come on top. Because we will get there. It's a matter of campaigns, and I see we have a good entry point to do that through the Court Users Committee, which is a multi-institutional stakeholder body, involves everybody. For instance, when I was in Kitale, we had so many problems of child abuse. And the court users decided we cannot stay downstream waiting for children to be defiled and cases to come to court for the court to sentence these people to 20 years. Because when you go to jail, you find the majority of the convicts sexual offenses. So that court user committee of Kitale Law Courts decided we are going to do a public education campaign. I was the chair of that court user committee, but I never went to any of those barasas. But they went to the chief's barasas, they went to the local radio to explain to people, here is the Sexual Offences Act. This is what it provides. It's a very serious act. If you listen to those radios, they were using very good examples. They were saying, if you go and violate somebody's daughter, you will suffer the consequences of the man who went to milk an elephant. So you know, when you use those terminologies, you now reach out to the people for them to understand what it is, what does it mean to milk an elephant. You will actually die, you won't leave the place. So that is what it means to violate a girl, to violate a child.
But my lady, my only concern is that being a patriarchal society,
Yes.
which you also mentioned, you find that it's your judges who, when they're interpreting the law,
Yes.
will also be informed by the same prejudices. In interpreting the law, they come up with the same prejudices that, you know, they are customary and, you know, their background, their history. So, which is why I'm trying to understand what would you now be able to do, even so that even when the interpretation of the law is being done, is done in a way that is also able to promote the same principles of gender equality and
Yes.
protection of the vulnerable, particularly the children.
Yes, I think when I'm CJ, the colloquiums, we will spend some time to get judicial officers understand what is required of us by the Constitution when you are making a decision. Your personal beliefs, your cultural beliefs, your religious beliefs, your own attitudes, you have to put them completely in the back burner. You just have to embrace the Constitution. Give interpretation of the values that are provided for in the Constitution. Give the meaning of the law as it is. It doesn't matter who you are. And then the rest, those who have received that judgment will grapple with it to see how to implement it.
Okay.
Then
Now,
that becomes another stage where we still go back to the court user committee to explain to people, you know, that if it's a judgment of the court, you have to appeal if you're not happy with it. If you appeal, you lose, then you have to live with it.
Yeah. Now, I want to spend my last few minutes on matters now that relate directly to administration issues, administration of justice within the courts, because it affects lawyers and, of course, by extension, the people that they represent. Because lawyers generally don't represent themselves, they are representing members of the public. Now, you mentioned about Kitale, where you went and the court was not functioning for about a year. And then you went there and, of course, you know, you resolved the issue, which is a good thing. And this has not been uncommon. I remember there was a time when the same problem was there in Eldoret. Lawyers were not being heard, they were complaining, and the courts were not functioning. There's a time it was happening also in Kakamega. So different parts. Now, how does a Chief Justice responsible for managing the institution allow a problem to simmer for a year, which is not just affecting the lawyers, but also affecting members of the public who need to access justice? How does that happen? What exactly is the reason that it's allowed to escalate to that level where, you know, the system of justice has come to a standstill for a year? And for you, what is it that you do to ensure that you don't have those kind of situations?
Yes, that is a very far-reaching question on the administration of justice and the relationship between the stakeholders, the bar, and the bench. I think modern management of the courts that are now well run by the principal judge for the High Court and for the courts of equal status, the end of the station, you know, I see now a better structure than prior to the reforms in the judiciary that would respond, I think, faster when there is a stalemate like it was in Kitale. Knowing how proactive even our acting Chief Justice has been, a problem like this will not even last a week before she has addressed it. My lady has been quite at hand to deal with it. This is a problem that should not be around to pester. Immediately it is brought to my attention. If I am Chief Justice, I would address it and find a lasting solution to it. The lawyers there were unhappy with the judge who was there. So that is a matter really to sort out quickly. It didn't have to wait for me to be sent there a year down the line. I could have been sent earlier. So that's another, a style of management. When you have a complaints office, you don't expand the complaints office. You deal with the complaints as they come, Then you don't have to be overwhelmed, and you don't have to clog the system with the complaints. Deal with them as they come.
Yeah, I agree. At least currently things are working better.
Yeah.
Now, there was an issue that was raised by Commissioner Warsame, where during your time as judges you are few and you'd be able, the output was much, much bigger, which is true. Because even I have now practiced for that years, and when I compare when the judges were fewer, things seem to be moving than now that we have many judges. Now, and he addressed the issue of, say, for instance, of a commercial division. And I'm just using that as an example. Now, would you think that sometimes when it comes to the deploying of resources, putting judges where they are best utilized, where you pick a judge who may not be very good, who may be very good in family law matters, on criminal, but not good in civil, in commercial matters, not being able to optimally use the resources that we have. Now, would you think that has contributed to the problem? And if it has, what steps would you take when it comes now to deploying of your resources so that you're able to be optimal in terms of even making sure that things are able to move a little bit faster?
Yes. Litigation has also increased, Honorable Commissioner, as opposed to pre-2020 because of the new rights that have been introduced in the Constitution. But there is something I've not been able to understand, whether also the land disputes have increased, because we used to deal with them together. And they were not that dominant. They didn't, to me, look like they are the ones bothering me. In fact, what was bothering me was the criminal cases, because I had to do the murder cases and all the appeals, the criminal appeals coming from all the magistrates' courts in Nakuru. But when civil matters were concerned, so there is something we need to look into deeply, and this docket allocation and the methods we are using for work. When we evaluated ourselves as the Court of Appeal, we also found that we write very long judgments, very long rulings. Like a ruling on a stay, seeking a stay of execution, the principles are already established. All you need to do is show this appeal is arguable. And unless there is given, it will be rendered nugatory. Do I need to write 5 pages on that? So we have come up with a process, a procedure of writing very short rulings, because there's nothing new. There are no new grounds we are breaking. And out of 100 matters that our judge is doing, probably one may be a groundbreaking, where you write a long judgment. The rest are mundane things. Mundane things. So those are things we need to look at and see whether we are spending more time writing very long judgments which are not necessary. Yeah. Whether everybody has their own docket or the cases are just moving on a conveyor belt, so that there is ownership and individual accountability. Kenyans want to know the value for money. The employers, we have all these privileges. At the end of the day, they want to know, and even me, I want to know, the Chief Justice wants to know, you know, what have I done for today? Am I entitled to this salary I earn? Am I entitled to this car that I drive? You know, individual accountability. And that will go a long way for people to understand accountability.
Yeah, but also, my lady, I agree with everything you said. Wouldn't it also be better, because we know judges who are very good in commercial matters, then they are taken to criminal division, or criminal division, they are very good at that, they are taken to commercial law division. Wouldn't it be better also to put somebody where their skills will be better utilized, instead of putting them somewhere where they're going to struggle?
I agree with that entirely, because like a judge who knows, you know, family law and likes it, has no issues, you better leave them in the family law. They'll be faster. Somebody who is good at commercial law, it is called matching talents, and I think it's the modern way of management. You match people's talents and put them where their output will be greatest.
Yeah, which brings me now to the next issue of transfers.
Yes.
And you know, this is something that there's a lot of grumbling among the judicial officers, the judges. Nobody ever wants to talk about it, but it's a real issue. Now, and there's a policy regarding it. Now, if you become our Chief Justice, what steps will you take to make sure that you resolve this issue? Because I know you know what I'm talking about, this issue over the transfer. And I can see you've mentioned somewhere that you're instrumental in coming up with the transfer policy in the Court of Appeal.
Yes.
You helped in developing that. Now,
yes,
how do you ensure that you're able to resolve this issue? Because the reality is there are some judges who are permanent fixtures, or some magistrates in certain stations which are considered good stations.
Yeah.
There are others who are always being thrown into what are deemed to be outlying districts. I mean, how do you ensure that you manage it in a fair manner, sticking to the policy and, so to speak, these complaints are dealt with?
Yeah. Thank you. I think my administration will be governed on the basis of fairness, and we follow the policy. I was the chair of the committee that came up with the Court of Appeal policy on transfers. And if there is a court where there is no problem about transfer, is the Court of Appeal. We all know that everybody wants to serve in Nairobi, because when you attain this seniority, you have established your family in Nairobi. Nairobi has all the facilities, hospitals, you know, everything. So everybody will want to stay in Nairobi. But we said, look, we are all court judges of the Court of Appeal. None is lesser than the other one. So we'll do rotation. You will go serve in Nyeri, in Kisumu, and Mombasa for 2 years. Those who are serving outside will come to Nairobi. Those who are in Nairobi will go outside. And it has worked very well. There are no quarreling. So for the others, judicial staff, judicial officers, and judges, the policy must be followed so that we bring predictability, we bring equality in the way we serve, that nobody is being favored. Everybody is being treated equally.
Yeah,
so
my last two questions, which I'll combine together because of time.
Yes.
I would want to deal with the issue of ICT.
Yes.
Because, you know, yes, there has been steps made, but we all agree that what we have now is auto manual. It's not really a proper automation. Accessing the system, lawyers cannot even be able to print receipts. There are a lot of challenges, and we are fighting over it. But we can't go back to manual. We want to keep moving. I need you to explain what steps you take if you become our next Chief Justice to at least start moving towards resolving this issue, that we are completely automated. It has become a tired story, you know, where everybody talks about automation. We are doing it, but in reality there are serious challenges which are also affecting our access to justice. I would need you to deal with that. Then secondly, which is my final issue, ensuring fairness amongst all in the staff, I mean everybody within the judiciary, and I'm talking specifically about, because these are things that also they're grumbling about, say for instance, a chief justice who comes, they start favoring their own, community-wise. We are also a country that is that has to keep grappling with the issue of tribalism. I would want to know, how do you deal with that? That if you are the chief justice, you are chief justice of all, and even the staff know that Mother Koome is our leader, and regardless of where I come from, it doesn't matter. I will need you to address those two issues.
Okay. Yes, the issue of ICT, I agree with you, is very important. I've been in this judiciary for 18 years now. And since I joined, we were to embrace technology so that ICT becomes an enabler, because it plays a very key role in especially record keeping. One thing that we should never lose is the fact that COVID-19 brought with it digitization. Because this program has been on. I go to Nyeri, I find cables are arranged all over. There are speakerphones on the table, but they don't speak. They don't record anything. A contractor was given money to lay the cabling, to put the speakers. They never worked. He took the money and he went. So that was a brightened project. When you start another one, we had a room here transmitting live proceedings, connecting with the courts. It also died. So now that COVID came and forced us to put in this, you are calling out or manual digitization, and I really thank the Honorable Chief Justice Maraga. He worked very hard to get that system in place, that system moving. We should never lose it at all. We should continue handing, seeing where it is not working, and build it up, and get the birds that work, get contractors who are credible, because I think the problem we have been having with ICT is not getting credible procurement of the right equipment that works. And I believe we can be able to get that. The other problem I've seen now that I've been working with it, there is the fear. We have to move with the staff. There are people who think that when technology takes over, they will lose their jobs. But the Court of Appeal has been able to assure everybody that we are retraining them. We are retraining them now to record the proceedings. Because even with a rudimentary mobile phone, you can be able to record. And when we started, Commissioner Masaria, you'll be surprised, it was very rudimentary. COVID came, we were told work from home. Urgent matters have been filed. So the registrar worked very hard. The registrar of the Court of Appeal, Mr. Selem, never rested for like 3 months. He was coming to court every day to see how the court can keep going. You would send us all the urgent applications or matters that have been filed with our emails, individual emails. When we started, we were actually communicating on our WhatsApp. We get the three of us, the bench that has been constituted. We discuss the matter on WhatsApp, and we agree, we do the ruling, and the ruling is issued. We moved to Zoom. We worked with the Zoom. Now we are on GoToMeetings. GoToMeetings is able to record even our proceedings, because when I'm Chief Justice, one thing that we should stop is recording proceedings with our hand, because we have to protect the credibility of our data, and we are courts of record. These records, which will be taken maybe all the way from the magistrate's court, sometimes all the way to the Supreme Court, is what the judicial officer or the judge recorded with their hand. And sometimes you get tired, you can fall asleep, you can gibberish some things which nobody can decipher, proceedings which really don't make sense. So we must own on to this with our teeth, if it means owning it with our teeth, until we digitize the judiciary. And it is possible. Even the problems we are having, those are teething problems that we should constantly address. But we should never go manual.
Yeah, I agree. The last issue, being a leader of all, tribalism.
Oh, yes. This is a critical question because of the perceptions. But I believe JSE has put in policies on hiring that take into account diversity, take into account fairness, merit consideration. I'm a human rights defender, Mr. Macharia, myself. I am a very equitable person. I am never driven by things that are outside the Constitution. I always see the bigger picture. So I wouldn't use my office to give favor to my relative or my tribe's person. These jobs belong to Kenyans, and we must actually comply always with the requirements of our Constitution and the policies that we have put in place.
Okay, thank you very much. I wish you well.
Thank you.
Thank you very much, Commissioner Jero. I will now request the Honorable Attorney General to ask his questions. Commissioner.
Thank you, Honorable Chair. Milady, good afternoon.
Good afternoon.
I will be brief because many of the questions I would have asked have already been addressed by my colleagues. But having described yourself as an transformative leader, could you summarize for us what you would consider to be your vision and transformative agenda for the judiciary over, say, the next 5 years?
Yes, thank you very much. When I was preparing, I read the Sonja reports, and I really commend the tremendous work that has been done in transforming the judiciary. First of all, looking at this constitution, it requires a reform-oriented Chief Justice who will be able to carry on that transformative agenda, that foundation that was laid by Chief Justice Willy Mutunga and has been trajected to the building blocks that Chief Justice Maraga has put in place. So my transformative agenda is to carry on with those transformation to fruition, because we know how delicate the judiciary is right now. We are at a trajectory where we can lose everything and slide back to where we were unless the reform agenda is pushed to another level. So I will begin with the evaluation of what has already been done. But one thing that cuts across and which still would remain the theme of my visionary transformative agenda would be to ensure that we have an independent judiciary that is expeditious in the disposal of cases, and that is sensitive to the Kenyans whom we serve, that is that centers the delivery of justice to the Kenyans. So the same objectives would remain, that is access to justice. First of all, ask myself, is justice accessible? We are talking of mediation as a forum, alternative justice system. We are talking about working with the counties and other stakeholders and identifying whether we need to build more courts, because we don't just build a court. As a judiciary, you have to engage the stakeholders and see whether there is need. When I looked at those two strategic plans, the distance, the average distance for a Kenyan to access a court is 175 kilometers. I would work hard to reduce it to maybe 100 kilometers in the next 5 years. And this is possible, working with other stakeholders. Then, of course, ensuring also the increment of the human resource capital register. I think I mentioned that it is low, it is 56%. Perhaps in the next 5 years, bring it to 75%, the staffing of the judiciary, so that we can deliver justice. There are many projects that are incomplete infrastructural needs. I think even where we are seated, we all appreciate that the Supreme Court, the Court of Appeal, should be not what it is. I remember, I think 2 years ago, His Excellency the President came here during the State of Nation address, and he was embarrassed to see where the judges sit in this building. I remember him offering even the KICC as a premises for us to use. But consulting stakeholders, this commission, I think we have a very nice area here where we can build a very nice, vibrant, extend the facility here. So I've identified also infrastructure, and I've also identified resources, resource mobilization, how to fast track the judiciary fund. I am a very good fundraiser. I was the chair of FINDA those days in the late 90s, the 2002. Our budget, our yearly budget was 150 million. It was a lot of money then. And it was a basket funding. We had no problems to get donors put money there. So this one, when you show them the deliverables, development partners, and you tell them this is our objective, to make justice accessible, to protect the rule of law, to coordinate the entire justice sector, and Kenya will be safe and free for all to live and realize their potential, and get a strong office that can also write grants, So we can get money in the consolidated fund, we can work with the counties to build the courts. And then ICT, of course, is central to all this, get good procurement systems in place, and an audit for money for value. Especially accountability is very critical. If you cannot show value for money, then that's why you get the push and pull. Basically, my vision would be to continue with the transformation that is already on the ground and propel it to another level and strengthen the judiciary, so that when I'm leaving, my legacy is that there goes a judge who was really a defender of justice, who was really a builder of an independent institution that can stand all the time. Yes, thank you.
Thank you, my lady. And what would you consider to be the greatest threat to achieving what you have just said?
There are many threats. First of all, this collaboration, this linkage with other arms of the government needs to be strengthened, need to be understood. The independence of the judiciary needs to be understood clearly, that it is anchored in the Constitution. Nobody can touch it. It is untouchable. It's a no-go zone. But government, because they have also been made worse by the COVID-19, which has threatened livelihoods. People have lost jobs. KRA is not able to collect taxes, but we are so privileged that we still get a salary serving Kenyans. So this is why I'm saying I will use my skill, my networks with partners, Like, for instance, when I served at the NCAJ, the Special Task Force, we never got any money from the judiciary. We drew our work plan, we identified the activities, we called UNICEF and INDLO and told them there were already partners working with the judiciary, and told them these are the activities we need to do to return the report that is required of us and the work that is required of us in the 16 TORs. And UNICEF said anything touching on the protection of children we will do. The US Embassy, Department of Justice also came in and said we'll do the service weeks, go around this country and finish all the pending cases for children because they are impinging on the well-being of the child. They are touching on their human rights. So we went around and did service weeks. And
so you fundraised?
We
yes.
fundraised and did the work.
Thank you. Let's move on to the aspect of collegiality, which was addressed by my lady, the Honorable, the Acting Chief Justice. This is the scenario, my lady. You're in the Supreme Court, and the Supreme Court, as you know, has a representative in this commission. And two of the members of that court indicate serious desire to represent the court. And that splits the Supreme Court in at least two very distinct, if not three or more. You are the Chief Justice. What would you do?
Well, I also come from a collegial court, the Court of Appeal. We are a collegial court, always also the chair of the panel, now leading the division. I belong to the leadership committee of that court. And I'll share the experiences of how it works, especially in sharing leadership positions.
But as you do that, could you address the question that has been put to your ladyship?
Yes, about collegiality. Collegiality, which I described as teamwork, works through consultation, discussions, and bringing the matter to understanding. The matter that is causing the disquiet, the matter that is splitting people, bringing it to an understanding. And in a court of 7, this is very easy to achieve. All we need to do is have a couple of ranches, because for the Court of Appeal we eat together, and when food helps people talk nicely. So we will have a couple of retreats eating to understand what is the problem. The problem is a member to represent the court to the JSC. We are only 7. Just see, one has already served, has already represented, so that one is out, leaving the other 6. I think 2 have served, so you are only leaving 4. Just discuss the formula that can bring fairness. And you can even say it will be rotational. This one, when they finish, next one will be this, the next senior most. Because these positions are not running away. And we should never lose sight, why are we Supreme Court? What is the mandate of the Supreme Court? What is the objective of the Supreme Court? That is the North Star. That is the guiding one. So this other disagreement, we talk, even if we have to go late in the night, until we agree. And we can agree because those are very few people to bring together. And I'm very skilled in negotiations and with humility in getting people to see the bigger picture and letting people see why we should sometimes cede even what we think should be ours.
Thank you very much, milady. Now, the Chief Justice offers jurisprudential leadership in the Supreme Court. How would he balance that responsibility or that role with the individual and collective independence of the judges and the court?
Yes, yes, because the Chief Justice is a judge beyond the leadership role he plays. When he wears the hat of a judge of the Supreme Court, he is one among equals. He is entitled to his own opinion, just like all the other 6 are entitled to their own opinion. So he can express his own individual view or opinion on the matter. And then if he is the presiding judge, he will listen to the views or the opinion of the others if they are sitting as a full court of 7. Then in those discussions, it emerges who is with him in his thinking and who is against. Let's say, who is for the appeal being around or the petition being around, and who is for the petition being dismissed. So that is how in a collegial court you discuss matters, and it has happened even in other countries, like in the US. If you read the story of Ruth Bader Ginsburg, RBG, one of the leading jurists in the US, she passed away recently. She gave the example of the Supreme Court of US, where there were very divergent views on a matter. And there they can really have a standoff because some people are aligned to the conservatives, others are aligned to the Democrats, depending on who has appointed you. And Ruth was very progressive, a Democrat, a human rights defender, really expressing herself in a way that was developing the law, including even proposing that US, which is a very closed community in terms of appreciating international law, we can use some of the human rights law and decisions, even from Africa, to inform and develop the law in the US on certain issues where we have made more progress. But she was able to work with judges who had very diverse opinion and backgrounds and views, because once you discuss in a collegial setting, you actually realize there is more that brings you together than what divides you. You know, there could be the very mandate, objective of the Supreme, of what makes the Supreme Court, that is the apex court, is the image of the judiciary, is the one giving us judgments that our president setting, is so overarching, is so overwhelming that I don't have really to dwell on the little matters until we divide the court and bring it out there as a court that is disjointed. So these are matters of discussions with top minds, people with opinions, but I believe there can always be a solution so that the Supreme Court projects an image of a court that is generating jurisprudence that is well-reasoned, that is authoritative, that is used as precedent.
Thank you, my lady. A couple of more questions. Where do you see the aspect of judicial activism in the development, future development of the Supreme Court?
I think the Constitution of Kenya 2010 has quelled any anxiety that we would have any gaps in the law in terms of interpreting the Constitution, the values there, the rights that are enshrined there, including socio-economic rights, rights for the marginalized, the rights for children, human rights, participation, consultation. It is so encompassing, the Honorable Attorney General, such that to go outside of this is really a very one-off situation that leads you to seek persuasive authorities from other countries or other sources. And then we have the augmentation of the international human rights law that have been accepted by our constitution to use if there is any need to fill in the gap.
All right. Finally, is there corruption in the judiciary, milady?
My goodness, I was hoping I would not be asked that question. I'll look at corruption from a two-pronged approach. Judiciary deals with cases of corruption. Corruption is endemic in Kenya. It has permeated our government, our society, the way we do things. There are very many cases of corruption that are pending in our courts. And that's part of the perception we have as a judiciary, that we are not fighting corruption the way it should be. And moving forward, when I'm CJ, we shouldn't engage in game blame. That, oh, is the prosecutor who didn't prosecute the case properly, didn't bring evidence? Is the police who did not investigate the matter properly? Is the lawyer for the accused person who didn't do what? And this is why NCAJ was formed, so that you look at the administration of justice and see where the challenges are. And the challenge that I will see is the fight against corruption. And when minds come together, there is always a solution. And the example I will use is determining election dispute cases. They are determined timelessly. Within 6 months, we complete them. Because all the actors come together, decide this the period of election. Courts, we train the people who will deal with the petitions. We put in a committee that monitors on a daily basis what is happening. If there is a problem, and my own Judge Majanja, I think, is one of our leading experts in those committees in monitoring the progression of election disputes. So we have expertise which we can use to help us come up with a system of case management of corruption cases, so that they are finalized within a reasonable time. A same committee like the election petitions can be put regarding corruption matters to fast track all of them and see if there is one which is having complications or delays, what is the problem, address the problem and let it move. That way, those cases that are pending there will be finalized within a reasonable time. Money will be released to the economy so that it can do what it is supposed to do. Then you talk of corruption, which is judicial officers, judges, judiciary staff, magistrates corrupt. Now, I can only talk for myself, but the perception out there is that we are corrupt also. We take bribes. Which is a very serious indictment, because systems can be put in place to nip this in the bud. If there are people who are moving around corrupting judicial officers, we have systems and structures that can be able to take care of that. We have the ombudsperson's office that takes these complaints and investigates them. JSC is in charge of enforcing the Judicial Code of Conduct, because it's a very serious crime. It's a criminal offense to take a bribe. So if all these mechanisms are put in place, I believe we can be able to nip in the bud corruption, or make it very expensive if somebody has been found undertaking corruption. They are dealt with, they'll lose their job, because when you go through criminal process, and it's a very painful thing to lose a job, that will deter others from engaging.
Thank you. You've just mentioned about complaints against judges, which prompts me to a question I hadn't anticipated, which is this. How would you address the backlog of complaints of judges, magistrates and other members of the judiciary pending before the Judicial Service Commission? That would be all from me, Chair.
Yes. Thank you. I think the solution is here with honorable commissioners. If they have a backlog of cases, we in the courts, we are dealing with, we are battling also with the backlog of cases and finding systems of finalizing our backlog. So the honorable commissioners, we will have to sit and see the amount of complaints that are pending, because as I said, complaints clog your mind.
Bear in mind, my lady, that you would be the chair.
Yes. Yes, when I'm the chair, then I'll convene a meeting for us to discuss how to complete these complaints. See whether there is a system that is not working. There's a failure of a system in discussing and finalizing these complaints. Because, you know, it's like a sword of demagogue also hanging on the shoulder of the judge or judicial officer who has a complaint when the matter is not determined. So JSC, I know you work through committees. See whether the committee is not finding enough time to deal with the problems, and give them more time, maybe give them like 2 weeks. They work rapidly, like a service week, to finish all the complaints that are pending, because it is not good to keep complaints pending forever.
Most obliged, Your Ladyship. Thank you, Chair.
Thank you very much, Commissioner, Honorable AG. I will now request Commissioner Gishohi to ask questions.
Thank you, Chair. Good afternoon, Honorable Judge.
Good afternoon, sir.
Yeah, I want us to look at something a bit different now. And before I go to it, something that has been going in my mind right from the beginning. Chief Justice of the Republic of Kenya, he talked a lot about Supreme Court, High Court, magistrates. I'm interested in small claims courts, where most of us, most Kenyans actually meet the judicial system. If you become the Chief Justice, seated in Nairobi, how would you, as a Chief Justice, be able to facilitate the establishment of this small claims court because of our small micro enterprises?
Yes, thank you very much. When I'm CJ, the Small Claims Courts Act is in place. The last time I checked, I think we were in Akorokwam and we were informed that it is already it's already in place. So what remains now is to operationalize these small claims courts. And I think a survey was done, if I'm not wrong, of where they ought to be opened. Again, budgetary constraints. With my fundraising experience, these are outfits that can comfortably be supported by the county government's CDF monies, because they touch the people at the grassroots.
My question, Honorable Judge.
Yes.
Are they functional? Are they operating?
No, I don't think they are.
Yes.
Yes.
So,
but I stand to be corrected. But
good.
I have not come across one which is operating.
And you know that is where the rubber meets the tarmac, because
Yes.
that's where the people are.
Yes.
Not in Nairobi. My next question, before I go to the other issue, you talked about the commercial courts. You talked about 3 years, maybe before a case is resolved. And you are living in a very competitive regional issues in terms of investment. I want to be very clear that as you come in as Chief Justice, the issues dealing with the business, enterprise, investment, what kind of a framework would you be able to institute? The same way you have cases on corruption and all those issues. What kind of framework are you looking for?
In fact, Honorable Commissioner, when the commercial division was established, that was exactly the purpose. That you can't own commerce. You can't own investors. Their cases must be decided within a reasonable time so that businesses can thrive. But within no time, it has been caught by the same backlog that has affected everybody. And earlier on, I think we said we need to look at the capacity of that court, the case management system that is in place, whether it is efficient, you know, really increase the capacity of that court. ICT, you know, these things, technology, working with technology lessens the time tremendously. So look at whether they have completely embraced technology in the commercial court, because it can even be a 24-hour court now that there is technology. When you are sitting at your home, you can work longer hours and be on a schedule until these cases are finished.
We hope that you can be able to address that matter, because it's something that is very urgent.
Yes, the SGT and also the Sonja report all say that a case should not be in court for more than a year. So this is something we have set, a standard that has been set, and we must aim to achieving it.
Now let us come now to the areas that I'm assigned. The Honorable Attorney General have alluded to this matter. As you come in my view, one of the areas that you need to look at very, very carefully is the structure of the commission. To ensure the commission works in a coherent, in a manner that is consensus, and you can be able to tap the talents within the commission. The other area of the judiciary, you might be doing very well. But if the commission is not able to support the judiciary, you will not go very far. I would like to hear from you. Two things that you do, taking into account you have the foundation from 2011 to 2016. You have 2016, 2021. I've been in this commission for 2 years. But I would like to see the chairperson of the commission, what new things that you make the commission move from its comfort zone to ensure that you are able to deliver our services to the Kenyans. Two things.
Oh my goodness. The structure of the commission. I think the first thing that I'll do is look at the strategic plan of the commission and see how far it has been implemented. I searched for it in the website. I was not able to get it. Maybe it's
not there.
Oh, it's not there. So that's the first thing then to address, the strategic plan. It's there. It's in the.
It's there.
Okay.
I proceed.
Okay. Look at what has been implemented and what has really evaluation of the strategic plan. The commission is a constitutional commission. It's one of the 15 commissions of the Constitution. So it's a very strong institution anchored in the Constitution to support the work of the judiciary. So the other thing I'll look at is also the funding for the commission. Is it well funded to be able to undertake its work? Because commissioners have half-time, I think, part-time. They are not full-time. They work with committees. But do we even have directorates, personnel directorates, because of the thematic areas that you're dealing with? Do you have, are they well staffed?
Okay.
With senior staff who are able to guide the commission? The few instances where I've interacted with cases from the commission, I've been able to see through the shortage of like the legal department. The legal department ensuring when there are disciplinary cases that have been scheduled for hearing before the committee, that there is compliance with all the requirements under the Judicial Service Act, the Fair Administration Act, and the Employment Act.
Okay.
Yeah, so I think there is a gap that I'll look into strengthening the legal department.
Okay.
Yes.
That's good enough. Still on the same matter, you look at I've looked at your papers, properly grounded on most of the issues. I looked at what you have written, I've looked at what you have said. You focus more on judges, magistrates. You have a population of your staff, 85% are not a judicial officer. They are basically your support staff. And I see that in 2011, 2013, you are the chairperson of the Association of Kenya Magistrates and Judges. And you did recommend some things to be done. But it appears the staff don't seem to have somebody to look at their matters. Now, as a chairperson of the commission, and this is the key staff that are supposed to support the judges, the magistrates. What do you put into place to ensure that the staff are properly motivated, their career growth is known, their productivity is measured, and the efficiency? Two things you do, particularly to the staff aspect.
Yes. That's a very important question because I was the president of the KMJA, and it's a kind of a welfare body that has been augmented of late by having the association for the staff. They now have their association, they are organized, they bring their issues as one, and then the KMJA that incorporates the judges, the magistrates, and the caddies also bring their issues to the table. We have the human resource department, and we have the training at JTI. What I have perceived as a disconnect is the training.
Training.
A coordinated approach to training that builds on the skills, that is targeted on perfecting the skills. And this is very difficult to achieve because the JTI is also under-resourced, it's under-capacitated.
We shall come to GTI.
Yes.
Just remain focused on
yes,
training.
So
is
now
one.
when it comes to staff, wherever they are working, that is where the training should take place.
Okay.
Skills on the job. If I am a secretary in the Court of Appeal, now we have gone digital. How do I fit in the digital platforms to help the judges transcribe the proceedings? How do I enhance my career from here? It means I stop being a secretary, I become an administrative assistant, eventually I become a PA. That kind of a career progression. And I think HR can have a department of career development.
That's very good. But Honorable
coaching,
Judge,
it's called career coaching.
Yes. Honorable Judge, I want to see yourself as a chairperson. The human rights, the directorates, they are there down there. I want to see that connectivity at a policy level as a chairperson of the commission to make sure those things are able to connect. Do you have an idea or what you do as a chairperson of the commission?
Yes, that I can connect very easily because I connect very well with the people. I hear their views. I mentor so many young officers here in the judiciary. So I interact with them easily, and this can happen very easily. You get a person who is trained in career progression, a person who is trained in the skills development, and they work out a program of training on the job, on the skills, and identifying the gaps and how you can project your career from where you are to the next.
Okay. For the final question on that line of human resource, earlier on, Commissioner Mashadi did ask you about tribalism, about those issues. Are you aware of a diversity policy of the Commission? And if you are aware of that policy, can you be able to lead that policy to Article 232 of the Constitution in terms of the values of public service as far as diversity is concerned in all public institutions?
Good. I hope there is, and it sounds very good, because it is one that can help the Commission attain the objectives that are set in the Constitution. So if it is there, I would make sure it is implemented. If it's not there, that we will develop one.
It is there, actually.
It is there. So then we implement it so that we comply with the Constitution. Because one thing I'm very convinced about the judiciary is that it is easier to set standards from the judiciary than from other institutions.
Okay. Let me finish off from that. I won't go now to the financial aspect. You talked about financial autonomy, because you can have all the other issues, but if you don't have the finances, you will be in serious issues. I want you to talk a little bit about public-private partnership as it is the judiciary, taking into account that the judiciary is supposed to resolve disputes with those people that might be able to do partnership with them. Can you briefly, maybe in 2 areas that you'll be able to address for us to maximize on public-private partnership, both locally, nationally, and internationally?
Yes, that's a very tricky, sensitive area, because we resolve disputes for Kenyans. We must always be seen to be impartial. So if you are entering into partnership, there must be a memorandum of understanding.
Memorandum of understanding, yes.
Yes, on the partnership. When it comes to decision making and the independence of the judiciary, that is a no-go zone completely. If it is the county government of Nairobi, we are partnering so that we build a court for the people to access. I don't think the county of Nairobi expects that when they come to court, they will be treated differently.
No, Honorable Judge, you had a case where you had a court in one of the counties, and the court ruled against that county. And the following day, they are getting orders to get out of the building.
That is why you need the MOU I talked about, that even if we rule against you, you will not give us matching orders.
Okay.
Yes.
Now, you talked about, you are very good in negotiations. I've seen it here. You know, resources are scarce. They are competing, everybody is competing for resources, including the executive, the legislature, and the Kenyans are paying for that in terms of taxation. If you get this position as Chief Justice, as chairperson of the Commission, at the head of this arm of government, I would like to hear from you, strategically, 3 key offices that you should be able to engage on that phone call that you say you need to call. 3.
3 offices. I think the Parliamentary Committee on Justice.
Parliamentary Committee on Justice.
Because they consider the estimates that have been sent for approval. The Treasury, that also does some work there, and even the executive, to explain to them the agenda, the agenda in delivery of justice, delivery of services.
Honorable Judge, I'm talking about specific offices in those 2 arms of government.
Okay.
You talked about registration.
Yeah.
I can be able to accept the committee on legal affairs.
Yes.
But there's another committee that is very key within that institution.
The one on allocation of funds.
Okay. Then when it comes to treasury, you know, treasury they are, you start from the desk officer, you are the chief justice.
Oh, I'll be talking to the cabinet secretary himself.
Okay.
I know him. We worked when we were developing the children's bill.
The other side of the executive?
The executive. I'll talk to His Excellency the President himself.
Okay.
Yes.
Very good. Very good. But I do hope that in those talks, you know, earlier on you talked about beauty contests.
Yes.
I hope this will not be a beauty contest.
That is where we will lay the ground rules.
Yes.
And say we are serving Kenyans.
Okay.
So all of us, let us put our egos aside and let's just think about the Kenyan delivery of service.
Okay. You also talked about in terms of accountability, and I'm coming to the end.
Yes.
And you have this soldier or the state of judiciary that is made every November or March.
Yes.
With very good cameras, photographs, good statement. Where does that report end up? And what feedback do you get as soon as you finish that ceremony?
Wow. I participated in State of Judiciary Report Forum. The law requires that it be given to the two speakers of the the two speakers of Parliament, the National Assembly and the Senate.
Yes.
It has far-reaching recommendations the last time I looked at it, like areas of law reforms, because judges, as they are doing their work, there are instances where they declare certain provisions of the law unconstitutional. So every soldier report has a catalogue of law amendments or law reform that is recommended. So they are given to the speaker. So I think what we need to do is whether to introduce another clause in the Judicial Service Act to say that the speaker of Parliament, the speakers of Parliament, will respond to those issues that are raised there within a certain period, or develop a mechanism of meeting to evaluate what each one of us is given. So we can call a meeting, like a workshop, to discuss the feedback, because every document like that must be evaluated. What did you do with the last one before we come to the next one?
Okay.
So we pick the issues that were needed to be implemented by the legislature, either Parliament or Senate, and then agree on the time frame when they are going to address them.
Okay.
So that is a forum that we can work with even before the law is amended. That can be introduced as a practice.
So
and
for the years that report has been tabled or addressed,
yes,
as a judge of the Court of Appeal, judge of the High Court, as somebody interested with the judiciary, have you ever had a feedback from Parliament on those reports?
Not quite. Well, they will say in forums, they will bash the judiciary, and when I'm CJ, I will invite them and say, let us discuss these issues, let's find the way forward, because you can't keep problems simmering.
Okay. Now let's come to GTI, the Judiciary Training Institute. I have looked at Chapter 6 of the report of 2018 and 2019. Talked about training, development, and capacity. In that particular report of 2018, 2019, I've seen a lot of seminars, a lot of retreats. Would you have an institute, if you get this position? I want to see how can you enhance that institute in terms of trying to develop very focused training and courses, both for judicial staff and the judicial officers. And would you consider partnering with other similar government institutions that offer same courses. What would be your take on that?
Yes, I agree with you that we need to evaluate JTI. It's a very critical institution for the judiciary. A lot of work was put to bring it to where it is, and it's one of the institutions we can never let go, because training cuts across. We need to sharpen our tools regularly for us to be effective. We need to keep learning. But the way it has operated is really very low in capacity. The way I see us operate is people come from all over. They are housed at School of Monetary Studies. They are bused to the institution, and food is also provided from another provider. So you are just coming there to use the room. So is it cost effective? Is it value for money to have people there, or to build an institution that is boarding? You know, I go to the JTI, I sleep there, I eat there, I attend course there. So that is a major work for this commission, because training falls under the Judicial Service Commission.
We are saying that,
and then
Judge.
training
No,
on the
Judge.
ground.
Yes, stop.
Yes.
Just 1 minute. You know, you will be the chairperson of this commission.
Yes.
Everybody will be looking at you.
Yes.
I'm chairperson of the finance committee. Yeah, for the last 3 months.
Yes.
You be my chair. You want to make sure that that institute is up and going in the right manner. I don't know the position it is now. Where
Yes,
they are.
it is very easy to catapult the enhancement of the JTI, because we are lucky. One of our founder directors is the Honorable Attorney General, who is sitting here, and he knows the desire and the need for that institution to get us funding, maybe to buy that place from the owners, and to put up a real training institute that is going to cater for the needs of the judiciary. So I'm going to engage with him when I'm CJ.
With the Honorable Attorney General.
Yes, he knows it, and we will get funding to build it.
Okay.
And then cascade the training to the stations,
The station.
so that we are training people from skills that are needed for the work that is before them.
Okay. So you hope that you'll be able to get the building up and going.
Yes.
I'm still on the commission. You are chairperson of the commission. If you come to those meetings of the commission, we literally close the market when you come to those offices. We literally close the ground floor when our share is coming. What will be your take in terms of finding a house, a place that the commission can be able to say, yes, this is the building that we can be able to work on?
That is also possible with proper engagement with stakeholders. Judiciary has some parcels of land in this Nairobi.
Yes.
And the commission can build their offices in one of those spots. I just pointed at this garden. If a building can be put here to house part of the operations of the judiciary,
Okay.
and another plot somewhere, we can build offices for the commission.
Okay. My final question, Chair. Communication.
Yes.
And I want you to address yourself in terms of strategy. If you don't tell our story, somebody else will tell our story.
Yeah.
You are the chairperson of the commission. What kind of communication strategy would you put in place to ensure that the commission is able to communicate with Kenyans?
Yes. Again, the commission, in a participatory manner, will develop, I'll lead them into developing a communication strategy that clearly explains the chains of command, who communicates on behalf of the commission, and what needs to be communicated. So that will be a participatory exercise by the commission to identify their own communication strategy.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. Thank you, Judge Koome, for those answers. I now request Honorable Felix Koskei to ask his questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Yeah, majority of my questions have been asked and you have answered. Thank you for the answers. I wanted only to get to know, because you've given us a proposal of what you are planning to come and do, which I agree with you entirely. But you gave us everything, a basket full of proposals. I want you to pick 3 in terms of priority, the areas that you will come quickly and look at. The 3, because you know, as much as you want to do all those that you have proposed, which is very good, there is limited resources. So I want you to prioritize what you really want to come in and do in the first instance. First 3, and why?
Okay. The first 3 priorities that I will address when I'm CJ. Technology is one, because it's in this nascent, it's in this development stage, this stage when it is very volatile, and we know many projects are killed at infancy. Try to breathe life to this technology that has now taken root, that Chief Justice Maraga worked so hard to put in place, worked so hard to support it. Number 2, and it works hand in hand with technology because it enhances the delivery of service, clearing the backlog of cases. Kenyans want their problems solved expeditiously. So what I will come in focused on is this multi-door approach that has already opened, make sure that it is operationalized. Court annexed mediation, alternative justice systems, ADL, and working with stakeholders. And when I talk about working with stakeholders, it's because I worked with them. When I was at FINDA, we were representing so many litigants who are pro bono. They couldn't afford legal services, but when they came, we taught them self-representation and communication. Most of them went and discussed their own cases, called the Mzee wa Nyumba Kumi. They discussed them and they finalized them. So that is another area that I'll focus. And then I'll focus on this operationalization of the judiciary fund, because we really need funds.
Thank you, Judge. Now, as an insider, and perhaps you have come across audit reports that are generated every other year, there are very serious problems when it comes to some units or departments in judiciary. One area that you have even mentioned is stall projects, project implementation, project management, project conceptualization, which you have rightly said that there are several that have stalled, there are several that have been paid, but the contractors are unable to complete them. Some courts, when you look at them, they were not supposed to be where they are. It would have been there are other deserving, counties or areas where they have a lot of cases that requires some space to use. That is one area that I will want you to tell the Commission immediately when you come in. What are you putting in place? That's number 1, so that you can answer all of them. Number 2 is about misappropriation of funds. When you go to stations, You get people that just, they steal the money, they use parallel receipts, they don't even bank the money, and that is it. The only thing that happens later on is for these people to go through a very long disciplinary process that eventually they'll be fired, but the damage will have been done and access to justice will have been hampered. What are you going to do about it? Number 3 is the issue again of human resource. You get rampant absenteeism. You get people drinks a lot. People at work, they are drunkards. They don't perform as required. There are a lot of unethical behaviors, and some even extract decisions of magistrates in a way that is not supposed to have been done. That is another area on human resource. What measures are you going to take, or what are you coming to do immediately when you enter the office to reorganize the issue of operation and management? You've talked about ICT. I don't think I'll go there. And the other number 4 is planning. Many a times we receive complaints, or we receive even reports from DPOP, of Directorate of Planning and Organizational Performance, and you realize that the judges and magistrates dispute their data. They say, this is not my work. I know what my output. I know what I've done in a month or in 3 months, and therefore I don't agree. To the extent now that it becomes the award against the planning. What are you going to do to streamline that so that we get harmony and we focus on real issues?
Oh, thank you. 3 issues about stalled projects, which you linked to perhaps project conceptualization and planning. And when I was preparing for this interview, it is clearly stated in the report that even if this money that has been allocated as the annual budget for the judiciary, the 18 billion, it is not all released together. It is released in tranches, and sometimes a checker is delayed. So if you had contracted somebody to build a court, and 6 months down the line money is not being released, then the project stalls. This is a serious conversation to hold with those offices that Commissioner Gishoyi has me, because when we have a project that is ongoing, everybody needs to own this project. It's for Kenyans. It's not really for judiciary, it is for serving Kenyans, so that that project is completed within the time that is provided. Another thing I mentioned, value for money. Is there value for money in this building? We all have built a house, so we can have an idea of what it costs to build a house, to build a court. So that's a very key area, ensuring there is value for money. And if that is done, I don't see any project stalling, because there is no suspicion, there are no audits that have been called upon, so that you can verify and then you can move forward. So accountability here, getting value for money is important. And then misappropriation of funds is a serious management issue that as the CJ has the oversight for the entire, doesn't micromanage the CRJ, who is the accounting officer, but must work hand in hand to make sure all the loopholes where judiciary funds are fund are sealed. And with technology now, that is easy, because judiciary is cashless. You can't transact, you can't pay for any service with cash or a check. you have to use the digital platform and make sure that those platforms are credible. They are also not sabotaged on the other end, so that people are putting money, but it is not coming to the judiciary account. It is going to another account. So that requires a very, very keen oversight. And then the other problem of the human resource, people coming late. We need to enforce the code of conduct strictly. It outlaws coming to work late. It outlaws being drunk at the place of work. And, you know, putting together these leadership teams, and I think the former Chief Justice is trying to do this, put teams, leadership teams in every court. And what I would hand to those leadership teams so that they are effective is peer review. If I'm the end of the station, I'm the resident judge, I'm the presiding judge, I consider myself the father or the mother of that station, to nurture all the staff there. If somebody is having a social problem that is causing them to drink, speak to them, call them to lunch, find out what is the problem, counsel them, and watch them, and you know, support them so that they can be able to overcome whatever the challenges that they are facing. The other one is data collection, PMMU on performance. Data collection is a big problem in the judiciary. And I say this from an informed position when I, as the chair of the NCAJ task force, special task force on children, we wanted data of the number of cases for children that are pending in our courts. It is a tall order to get data. And also when you get that data, its credibility, whether it is correct. So another culture which we need to inculcate, and I'll take this very seriously. And even when I called, because I'm a trainer for judges, for magistrates, newly recruited judges, inducting them, I always tell them, when you go to a station, the first thing you need to know is your data. And the best institution that has best data keeping is the prisons. Oui. Today, if we visit any prison, the person who will meet you on the gate will tell you, today we have so many prisoners, so many women, so many men, so many children. But when we visit the court, nobody will stand there and authoritatively tell you, today we have so many civil cases, so many criminal cases, so many, and this is their money we have collected. So that kind of accountability and ownership by the stations themselves, that I can be able to work on.
Yes, I think you've answered. I still have a problem following up from Commissioner Gishoi and Commissioner Macharia on this issue of diversity, issue of tribalism, or the so-called face of Kenya in an institution, which it looks like it's a lip service. People just talk about it, but they do nothing about it. To the extent now that even during recruitment, there is no conscious decision to right the problem, to correct the issue. No, so I don't know, what is your view on this? Because when you see Article 10, it is very clear. On inclusivity, all that. And everybody, everywhere talks about it, in all institutions, whether executive, legislature, judiciary. They talk about face of Kenya. But when you really go down to look at it, nobody does anything about it. Nobody's correcting it. As you are coming in as a new Chief Justice, what is your plan to correct this problem, which is a constitutional requirement? Is there any plan that you have that will enable us correct the situation? Would you like propose that, as we are advertising now, as we perhaps have gotten enough data to know how many are coming from where. We even indicate and say people from Himalayas or Florida need not apply to balance of the numbers. What is this that you will come and do to ensure that the judiciary as a justice giving institution will be an example to others, because that is the problem. Number two on that, so that you can answer all of it, and that will be almost my last question, is we are also concerned because you bring in a senior person like a Chief Justice like yourself. You come to the office, and within 3 months, the first thing he or she will do is to flood his or her office with people from the same village. To the extent now that even the language in that office, even business, official business is transacted in a particular, dialect. How we need assurance that when you come in here, you will be a true Kenyan who will ensure that each and every deserving person, whether she or he is coming from the village or from the end of from El Molo area or wherever, will get an opportunity to serve in judiciary, and more so an assurance, because we've seen most of the time you get, not only in judiciary, everywhere else, a senior person practicing what we call nepotism, positioning either his former schoolmates in strategic areas, his tribesmen or her tribesmen, or people who they go together to a particular church or they belong to a prayer group. How are we going to handle this? Because we can get very good officers who have very good ideas, everything. But this menace, this problem that has caused a serious problem in this country, always brings down those good officers and good people who can run departments and institutions in this country. Could you please highlight those ones and tell us what action are you going to take to ensure that these problems are corrected?
Yes.
Thank you.
Thank you. And this still takes us to the policy, the JSC policy on diversity, which I believe was informed by those problems, Commissioner, you're discussing, and it looks like it's a major problem. So probably this diversity policy is not being implemented. And I, as the Chief Justice, I will make sure that it is implemented. Staffing the office with my kinsmen or kinswomen will not happen. I'm a person who is driven by very high values of professionalism, a human rights defender, a defender of the Constitution, and which is really a calling and a requirement for my office as a judge, that I cannot favor somebody on the basis of the tribe, and I must always be directed by the values that are in the Constitution. So having come from that place I described for you and arriving at this Court of Appeal judge that I am today, I'm not about to bend my oath of office to favor somebody in any way, either in the case or in the job, to bring them to my office. I wouldn't even be able to work with them.
There is a statement you gave when you were responding to one of the commissioners, and you said when you were in Nakuru, it reached a time when you told advocates and I don't know who, the stakeholders, that I don't hire magistrates here. Can you go to Nairobi and go and sort it out? Do you think it was a fair decision?
It was the right way to deal with the problem because litigants were suffering. And I had written letters to the office of the CJ explaining that we are short of 5 magistrates. And litigants are suffering. The ones where cases were already fixed, they are coming and going. They are almost on now staging riots. So when we had a meeting with the bar and bench, we examined the problem. Where is the problem? I've written letters, no response. I've placed calls. I haven't gotten any. So I said, please go and see the registrar. I'm talking to him. I'm asking the letters I've reached. Please go see him and let him book an appointment for you to see the CJ, because the backstops are the CJ. That was the right thing to do then.
Yeah, thank you. I thought it would have been you yourself coming to camp at the CJ's office.
I had done
or
it.
registrar.
I had done it, Honorable Commissioner. I had written letters, I have made calls, and I had actually come to seek an appointment.
So it's only that you answered very well when you talked about how you will push for recruitment or appointment of the 41 judges.
Yeah.
You rightly answered that you will book an appointment and insist.
Yes.
Because I had already had that fear that now we give you this position as Chief Justice.
Yes.
The executive refuses to hire 41 judges, and then you will tell everybody here, can you walk to the house on the hill and ask him to
Yes.
to register? So I thought it would be fair to as a public officer to really take the beating on behalf of the public.
Yeah.
Go, come, sort out, and then you say, okay, I've gotten one, I've got to do yourself, so that you become the face of the Chief Justice without necessarily allowing people to come and
Yes.
look for. Yeah, that is what I thought.
Yeah,
But-
luckily because of the bar bench interactions.
Yes.
Even when we had that meeting, I called the registrar and said, please give appointment to these lawyers from the Rift Valley Law Society. And he gave them the appointment. So they
Okay.
went to the registrar on an appointment.
Okay.
And then he had quickly worked with the CJ and to resolve the problem.
So it worked out.
It
Thank
worked
you.
out.
My final question is on community service.
Yes.
I want to commend you for being very passionate in community, giving back to the community. I have seen you interact a lot. You have a hospital that you support. You have children. You have some institutions that you support. That is very commendable. What I wanted to ask is, could you explain your philosophy of this public, involvement, and how will you use the same spirit that you have now, perhaps even to mainstream it in your office as CJ, and even to bring it down even to the entire judiciary as a policy, to have that face of having empathy, trying to help in a way that they are able, whether it is CSR, or how will you bring in and you mainstream it in your office and the entire institution?
Yes, I think that will be easy to work because many judges, led by my lady, the acting Chief Justice, are all involved in the CSR work. There is no weekend you will not hear, because we are on another platform, people sharing how they went to mentor school children, how they visited home for the elderly, how they visited a children's home, how they, mobilize some CSR activity. So we are doing it individually, but what you have proposed is very important. How can we have this policy? And I know within the Kenya Women Judges Association, this is very easy to come up with, and so is KMJA. They are all very community oriented. That is the beauty about judiciary judges and judicial officers and judiciary staff. They are all very community oriented. So this one will be very easy to implement. What drives me is that my Christian values also, I'm supposed to look out for the vulnerable and lift them. And if that is the focus of the judiciary, let us leverage the power and authority that we have, the power of convening. Even if you are a judge in a court station, you can convene and command a lot of authority to bring together stakeholders by way of court users to work towards a problem that is there in that community. Say street children, you can be able to address that problem, deal with the street children in that town or community, or whatever activity that you identify. This is a calling actually for all of us, even under the Constitution. We are supposed to look out for the vulnerable. We are supposed to look out for the marginalized.
Thank you, Judge. The last of last, JTI. JTI is an institution that is not independent, it is not semi-autonomous, it is just like a department. What is your view? Would you want it, or would you propose a policy where it can become autonomous or semi-autonomous, that it will have its own director hired, a full-time director, so that we avoid this situation of picking a judge to go and work there, losing a lot of time on his or her core business? What is your view, and what is the tradition all over the world on this issue?
Yes, Judicial Training Institute is an institution of very high stature, a very important institution in the administration of justice, in the rule of law, in the constitutionalism, because it generates information, it trains, it help in the administration of justice. And I remember there were discussions to have even an act of parliament for the Judicial Training Institute that puts in the structures of governance, funding and all that. And I think the ideas you have proposed are very good, that we need to scale it up to an independent institution, standing on its own.
Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Lastly, we have Honorable Evelyn Orwande to ask you the last set of questions. Commissioner.
Thank you very much, Chair. Judge, it's been a long day, but I just have a few questions. A lot of the questions that I had have already been asked and answered. I just have a few questions maybe emanating from some stakeholders, which I may have to ask you, just so that you can give us your perspective. Now, there's a feeling with some of our people out there that the way our courts are interpreting the Constitution, it opens up doors for foreign concepts that may not necessarily sit well with our values, our morals, and our culture. Now, I'm looking at the NGO case and your decision in that case. From where I sit, I could see that you are drawing a line between the state of being a gay person and actualizing whatever amounts to a criminal offense under section 162, 163, and I believe 165 of the Penal Code. In your judgment, if my memory serves me right, you say that if I stood on a hill and announced to all and sundry that I'm gay, I have not committed an offense until I actualize it by committing whatever acts are provided under those sections of the Penal Code. Also, the judgment of your colleague, Justice Waki, he made an analogy from the Bible about the adulterous woman, where Jesus told her persecutors, whoever has not sinned, cast the first stone. In my understanding, I may be wrong, but in my understanding, the judge was sort of telling us not to be hypocritical and to get off our moral high horse and confront the issues that are on the ground. So do you think in that decision, or your decision in that case, is a manifestation of those fears?
Thank you, Commissioner Rwanda, and congratulations. I think I haven't met you since you were successfully elected to this office. I'm proud of you. I was the president of KMJA, so you are also my representative. This question, I will be very shy to answer it because this case is alive. It's in the Supreme Court. But it was a case of, we did not go to the interpretation of Section 162 of the Penal Code. It was merely a case, should this NGO be registered? And what I said and what was the ratio in that case in the majority decision is that you cannot discriminate a person because you are assuming they will commit an offense. And that actually explains, if I say I'm gay, I haven't committed any offense, nobody can arrest me. I can't assume as a judge that you're going, and what is gay? I don't know. You know, you have to bring evidence to convince me that you have actually contravened the Penal Code. So let's not go far because it's sub judice.
Okay, Judge, let's leave it at that. My next question, I want to give an analogy. I am the Chief Justice. I, Olwande, am the Chief Justice. And there's a kadhi somewhere that for whatever reason, I have an axe to grind with. So a complaint has been raised about this specific kadhi, and I see an opportunity maybe to settle scores or to punish them for whatever, to punish him for whatever issues I may have with him. So I look at the provisions under the third schedule of the JS Act concerning the delegated powers that I wield as a Chief Justice. And I decide that, in my opinion, I am satisfied that public interest demands that this kadhi should not continue the functions of his office. So I go right ahead and interdict him. He is on half pay, and I keep it that way for 2 years. Are there any checks, aside from this kadhi going to court to sue me? Are there any checks in the administrative structure, or even in the legal structure, to stop me in my quest, when you look at our framework? Thank you, Judge.
Thank you. I just want to assure you, Commissioner Rwande, that it is possible for you to become CJ. Indeed, you can become. Dreams are varied. You can become the CJ. I think I've encountered this kind of problem that you have stated in this analogy. Because the JSC Act gives powers to the CJ to interdict a judicial officer in public interest. But you know, that has to be considered alongside the Fair Administration Act and the Employment Act. Because this is an employee, this is a human being, this is somebody with a family. You have to subject them to those processes. Call them, give them notice, notice to answer to the allegations, listen to them. Then if you are not satisfied that they have answered properly, and then you initiate the process that is provided for.
Judge, permit me to interject.
Yes.
Yes, that framework is there.
Yeah.
We have the Fair Administrative Actions Act and all the whatever provisions in the Constitution. But what I'm asking, in the anything to hold me to account other than this person going to court within the structure in which we handle our complaints and the disciplinary process.
Whether...
Sorry, remember I am here. What I'm driving at, is there any structure to check me in my abuse of these powers?
Oh yes, I get you, Commissioner. The structure of checking excesses of powers of the office of the CJ, judicial review is a remedy that one can use to check excesses of power by any public officer. And I think in this case it's been used effectively. We've seen decisions being overturned.
Okay, thank you, Judge. Maybe I can move on to the next question that I have. The next question that I have concerns the issue of vetting. Vetting judges. Maybe not necessarily by that name.
Yeah.
But historically we have seen there have been several occasions when the judiciary has been, or the judicial officers, that I'm using that in the wider sense to include judges, have been brought up for what I'd call, for lack of a better word, cleaning. We are always cleaning the judiciary. We had the radical surgery, we had the vetting, and it seems the problem has not been cured, because right now we seem, and there are those fears, that we are hurtling very fast to yet another process that we see is cleaning our judiciary. There are fears out there that this ultimately waters down the independence of the judiciary. I would like to hear your views on that, Judge.
I'm in total agreement with you, Commissioner Olwande, that every institution should be able to clean itself up. You should not open yourselves to outsiders to come and clean you. So we need to look at ourselves and see whether we are actually addressing the complaints that come to the judiciary effectively. And we must ring-fence the independence of the judiciary. The independence of judges, the independence of our decision-making, and the independence of the institution. This institution is not there just serving us. It is going to serve generations to come. So it's important to maintain the dignity and the independence of the judiciary. This is why we must always be evaluating our processes and getting feedback of where it is not working, and dealing with those problems and dealing with them properly. If there are complaints, we must address those complaints and tell the complainants what is the outcome of the problem that they registered with the judiciary. So that we do not water, like you put it in your own words, water down the institution of the judiciary. The vetting, the radical surgeries, Kenyans are in agreement, do not yield the results that are required. So we must have a system that is inside, that deals with the problem, a very strong communication department that communicates with the public the decisions that are made by the judges, that are made by JSC when they are determining those problems. Keeping a problem for a judge who is on a Kadhi who is on half salary for 2 years waiting for a determination of their case, that's a violation of his human rights. It should be dealt with, and this is something you can agree on. When I'm CJ, we put a system, when cases come, they go for case management, and the committee sees what requires a hearing. What doesn't require a hearing, they tell the parties, and they communicate even to the complainants. What needs hearing, they fix them for hearing. And they make sure that, this is why I was talking about a very strong legal department within JSC that makes sure that all the processes that are required under the JSC Act, Fair Administration Act, Employment Act are followed. And it's not difficult to do that.
Thank you, Judge. I'm hoping that if you make it to Chief Justice,
Yes.
should we ever come to those crossroads when we have to deal with the issue of vetting,
Yeah.
you'll be a big defender.
You remember
the-
when I was the chair of KMJA, I crusaded the rights of a fair hearing and fair processes that does not interfere with the dignity of the institution.
Okay, thank you. Back to the issue of, the period when you were chair of KMJ, I've seen in your CV that you mentioned that you were involved in negotiations with the SRC for the fixing of the salaries and remuneration for judicial officers. It appears that some issues or some concerns concerning the remuneration of judicial officers were left out in the review that have necessitated KMJA to go to court. My lady, in this institution, we have an RM whose take-home salary is 90,000. Kenya shillings 90,000. And who, other than the other pressures of life, has to worry about making it from his house to work and back safely. They have no security. And I believe for a judicial officer of whatever rank, something like official transportation is not a status symbol. It has a component of security that comes with it. KMJA went to court against the SRC. There's a judgment out there. So far, nothing has been done. As Chief Justice, you're the Chief Administrator and more or less the face of the employer of the judiciary. And employee motivation and ensuring that they're well-resourced becomes part of your business. If you become Chief Justice, you'll be coming into this scenario, and we would like to hear from you what you would do about it.
Yes, thank you. This is also another live matter that we have to be very cautious about, because I think the decision of the High Court is on appeal, so I'll be very guarded in my answer, but just dealing with the principles, RMs should be remunerated properly. And maybe after I left my term, this issue should have continued negotiations. The negotiations we had with SRC were very, very difficult negotiations. Wherever place they went, we made sure we were represented, so that KMJA representative will stand up and make a case for the magistrates. So we drew a plan of how to follow up that case of the review of the magistrates' salaries. And even after the recommendations were made in the report, implementation was another problem. There is no office, we didn't knock to see that implementation was done. So if this issue of RM was left and it's been determined in court and there is a judgment, that we will see to its implementation. alongside other judgments that are pending. Because compliance with the court order is critical to the rule of law. It undermines the rule of law when court orders are ignored, because the next day there will be no need for people to go to court. They will resort to their own mechanism. So when I was thinking of this position, what I see as a way out is that the National Council on the Administration of Justice should have a department on the implementation of court orders, because where the court orders have not been implemented is where the government is involved. So that can happen. So that it is the concern of the AG that judgments are not honored, decrees are not satisfied, because he is concerned about the rule of law. He is concerned about the administration of justice, undermining the administration of justice. Is the concern of every ministry that is the judgment debtor, that they haven't paid the judgment debt. So can we regularly review these judgments and see why these ministries are not paying? I know a big exercise was undertaken earlier on by one of the governments, I think the NAC government, the Kibaki government, of evaluating the pending bills, seeing what is the hindrance in this. So this is something I would be able to deal with and sort out. Yes.
Let's now move to there's one that we received concerning a matter you handled, the National Cereals and Produce Board versus Erad Suppliers and General Contracts Limited. And the gist of the complaint is that you issue an order of stay of execution, or you are part of the bench that issued an order of stay of execution on the strength of a letter which you received from the Permanent Secretary in the Ministry of Agriculture, which was addressed to the Registrar of the Court of Appeal. So the complainants in this matter are raising concerns about your independence and your integrity. What would you say about that, Judge?
Yes, thank you for raising that. What I would say is there was an application for stay of execution before the court. There was a notice of motion seeking stay of execution. I was in that bench. It was the decision of Githinji, former Chief Justice Maraga, and myself in 2012. I'm surprised nobody raised that issue when Justice Maraga was on this seat being interviewed. So when the matter was called out, the presiding judge was Justice Githinji. And as he was going through his file, and mind you, the file of the presiding judge is the one that carries correspondence, he removed a letter from his file and said, also in addition to this application, the CS has written saying that they are about to be attached for so much money. It was a lot of money. I think 380 million. A serious board was about to be attached. Please, can this case be expedited? Litigants write that every day. They write to court saying, please, can you have my matter heard? So we deliberated on the application on whether we should give an interim stay to stop the execution. And we were of a unanimous decision that we needed to stay because the facts of the matter revealed that the appeal was arguable, and unless stay is granted, serious board will be attached and they will have no way of recovering this money. This is one decision that goes to show timely intervention, judicial timely intervention, can save public resources, because subsequently it's public knowledge that Erad and the directors were charged in a criminal case for corruption, fraudulent dealings and production of documents which were fake, and they were actually sentenced to so many years and fined. So I don't see what we did which was wrong in that decision. It subsequently went to the Supreme Court, and the Supreme Court agreed with us.
Okay, thank you, Judge. I'll now move on to the documents that you had submitted. You submitted a wealth declaration. We required your last 3 declarations. You submitted only 2. Why is that?
That was an oversight. Because I saw you ask that question to my colleague, Justice Itembwe, I went back once and I read, we were submitting many documents. That was an oversight. I have the third one and I can submit.
Okay, thank you.
Yes.
At the same time, you also did not submit one for your spouse.
Okay.
Would you be willing to submit that as well?
Absolutely. By tomorrow.
Now, I looked at the wealth declaration form you filed for December 2017. In the description of assets, you have an asset, you had 2 houses, one worth 10 million and one worth 8 million. I think one is 209/386/6, and the other one is apartment number E12. In the subsequent year, in the subsequent declaration, you also had another property, that is house number 148, site and service, is it Kuzet, worth 500,000. And in your current declaration, the latest declaration, there is no indication of these 2 properties, yet there's no commensurate income, but maybe we would say you disposed of them or something like that. Maybe if you could explain that for clarity.
Perhaps this is also an oversight that I need to check. Those properties are still there. Koje is a house in Meru, still there. Yes. Yes, I can update.
That's all I have. Thank you.
Thank you very much, Commissioner Orade. Commissioners and the judge, we have come to the end of this interview. Yes, Commissioner Mwilu.
Thank you. I know you are tired, my lady, but you have sat there as long as we have sat here.
Yes.
Good. Now, I need to clarify one thing from this end myself, and then clarify 1 or 2 things from that end. The first one is that, of course, this interview is being watched everywhere, and it's a permanent record. And I would not want, on behalf of the institution that we serve, to remain on record the fact that we do not have small claims courts. This country has something called ease of doing business, and which is a condition we have to meet under the World Bank standards. Under that commitment, I gazetted 3 magistrates to commence a small claims business, a small claims court in the Milimani law courts only about a month and a half ago. So so that we are not underrated because of my lady, your statement.
Yeah, congratulations.
And
really
I thank
proud
you.
Of this initiative.
This country does have
Yeah.
small claims court, and we have already in Nairobi 3 magistrates undertaking that exercise, for which reason we upgraded our rating.
Great.
But for COVID, I would already have done another 2, but because of lack of movement, that has to wait until the country is reopened. At least the 5 counties are reopened, and then we are able to move and launch those. That clarification made, my lady, I am obliged to ask you this question, because as our team leader, you are the role model. When answering questions from Commissioner Majanja, you said that the matter that you had outside hours, you compared that to the midnight sittings of the Supreme Court. My lady, you and I know that we have regulations that derive from the offices we hold. And I need to mention here that first, the Supreme Court has only 14 days within which to deliver an extremely important determination. That's number 1. Number 2, for the Supreme Court to sit at midnight, as my lady said, it took the Chief Justice to authorize sitting out of and beyond hours. As is the practice, my lady will recall that when you and I were in the High Court, the Court of Appeal had occasion to make determinations and have them served to a particular sister judge of ours who was sitting up to 8, 9 o'clock in the night, and the Court of Appeal overturned those determinations because the judge sat beyond hours and without authority. So the clarification I further seek following, my lord, the commissioner's questions is this, my lady. Did you establish the bench? Did the bench establish whether or not the CJ had authorized a sitting outside hours, the importance of the matter notwithstanding? Did the bench authorize that? And since you sat on the bench and you are the one being grilled, my lady, you are the only one who can answer that question.
Yes.
The third and final issue is this. When Commissioner Gishoi, and I think also, yes, Commissioner Gishoi at least, asked, or did it begin earlier, how you will resolve the problem of the 41 unappointed judges, now 40, you said that you would pick a phone and call the appointing authority. Those are my lady's words. This is my question arising from that answer, and it is this. You and I were still serving here when our immediate outgone boss stood on these stairs and told us that he had tried to make calls, and calls were neither picked nor returned. That is in the public knowledge of the people who live in this country. Does my lady have, one, either an assurance that my lady's calls will be picked, or two, a way that will make my lady's cause be picked? Sorry, I said it was the last question. It isn't. The other one, like my brother, Commissioner Macharia, I knew you when I was still in practice from your activism. Okay. Something you were very proud of during those days, and something that those of us who saw you then cannot divorce from you. You know, you hear Mother Koome, my lady, the first thing that comes to you is this. This is the girl who fought government. You so fought government, and you and I have discussed this thing several times, that there were times you were just scared whether you would be there the following day. Remember? As my lady changed, as Chief Justice, is my lady going to fight government? If the answer is yes, how is my lady going to do that? And please don't tell me, don't tell us that you would now be the CJ, because activism is activism. If my lady would not fight government, whatever fight government means, and I want us to refer to the period that is in the picture right now, and which my lady explained to us. You said during the Kanu, you said that. During the Moi, you said that era. You were running all over. We saw you, we heard you. So has anything changed? And would you do things in the same manner? If not, why not? If you, the first clarification was from our end to protect our work. The other three are for my lady to respond to. Okay. I thank you once again.
Thank you very much, Honorable Acting Chief Justice. I think you have clarified the last one when you said it was really not a fight, a physical one, because we were presenting ideas and arguments why we should have a constitution reviewed. We were presenting the values that are solidified in the constitution, the benefits for which we are deriving now. We were asking the government, please respect equality. Equality is a value here. Please respect human rights. Human rights cuts across this constitution. So what I was doing as the chair of FINDA was situational. That is the job that I had. That was the job description that FINDA gave me. As the chair of FINDA, please, we need to get law review where equality is respected, there is non-discrimination, women and children are protected, the vulnerable are protected, people are no longer arrested and charged with trumped-up charges because they are in a meeting. People are not arrested and detained without trial. That was defense of human rights. And I think I explained earlier in my presentation that whatever work God puts in my hands, I do it with passion. I remove all my arsenals to do that job and achieve what it is that I have to achieve. Now, as a judge, have I changed? Completely. I have changed. Because the job description of a judge is to decide cases that are before the judge, not to express any view that may compromise your decision-making ability, so that when people come to court, they ask me to recuse myself. I have to abide by the code of conduct of the judiciary. So my performance as a judge in the last 18 years speaks for itself. That was a former job. And I think many people have a former job and a new job. So this is the new job that I have. I am government. As the CJ of the Republic of Kenya, I am part of the government. I'm handing the other arm of the government, and therefore I will engage them in finding solutions to all the problems that we have. This is our country. It's a beautiful country, capable of delivering on all fronts, social, economic, political. So we need to pull together and deliver, and making everybody understand what is independence and what is interdependence and what is service delivery. So that I would assure you, my lady, that we will work in a very coordinated approach, always the Constitution being our north, our code of conduct, the Judicial Service Commission guiding us on what to do. To resolve the 40 cases of judges that is pending, you asked me whether I have any assurance. I have none, because I don't know anybody in the executive. The closest I came to His Excellency, the President of the Republic, is when he came here on launch of the State of the Judiciary report, and we were invited at the stairs there to take a picture. So that is the closest I've come. But I know when I'm occupying this office authorizes me to pick up a call and ask to speak to His Excellency, the President. Even if it has been tried before and it has failed, I'm not the one who tried, so I must try it. And I have faith. I'm a woman of faith. I believe I will be able to explain why I want to speak to His Excellency to have a meeting. And I believe he will give me, because it's not for myself, it's not for my sake as Martha, it is for the sake of the Kenyans. And then the last one, my lady, you asked, was whether we've checked whether the CJ and authorized the sitting that happened beyond the hours. When we were in the High Court, we did not have the High Court Organization Act, and we did not have the Court of Appeal Organization Act, that now gives power to the President of the Court to arrange the course list and empanel the judges. So the authority and my power and my supervisor is the President of the Court. So if the President of the Court has empaneled a bench and he has drawn a course list asking that I come and sit, it would have been insubordination on my part to say I will not come to court. I am a Kenyan, I'm a responsible citizen, I am a judge, I know my responsibilities in exercising my discretion. It is always to attain justice. At the end of the day, you ask yourself, what is the justice of the matter? And when I came to court and I read the file, I saw the justice of the matter was to avert a constitutional crisis, because the Constitution does not provide, if the repeat election does not happen, what happens? I saw the country going into darkness, and I said, if exercising my discretion to stay the order can save the country from a constitutional crisis.
My lady, the merits of the matter are not in dispute at all.
Thank you.
We're talking about the process. To date, maybe I could also mention here, to date, it is still the Chief Justice. I haven't seen the provision in the 2012 Acts, the Court of Appeal Administrative one, the High Court one, the Magistracy one, where it is stated that the power was taken away from the Chief Justice to authorize a sitting either on a public holiday or beyond hours. And it is still the Chief Justice who gives that. Maybe that is one of the first assignments we work on when you arrive.
Okay.
Thank you very much, my lady. Thank you, Chair.
Thank you very much. So now we come to the end of this session. I would like to thank you Honorable Judge Koome for coming for this interview. Thank you for your honesty. Thank you for being very open in answering the questions that were put to you by the commissioners. And let me also add that we also thank you as a commission for the work you are doing, yourself and your colleagues, judges, in terms of administration of justice, for Kenyans. So we want to thank you. We also want to ask you at this point, Honorable Judge, whether you have anything to tell us, maybe something you left out and you feel that the commission needs to know.
Okay.
And after that, you can ask any question that you may have.
Thank you very much, Chair. It's been a long day, I agree. Like a good lawyer appearing to present myself and sell myself, I reflected on myself and what I would do, what strategy I would employ, what networks, what kind of leadership I would bring to the judiciary. I kept on writing notes, then I typed them, and I decided to produce a submission, which I said you'll be given a copy for record. I have spoken until I'm hoarse. Excuse me.
Maybe Frida, you can help the judge to open the
So difficult.
the bottle. Oh, okay. So, Honorable Judge, we actually had, that was brought to attention, but we felt that because we had not given that opportunity to other applicants, we didn't want to see it before. Okay. But now that we have talked,
yes,
you can submit it to us. Thank you.
Yes, I think a copy has been availed to you. It gives my strategy, what I perceive to be my role if I became to the Chief Justice. It has a rudimentary drawn strategic plan that has my vision to build a judiciary that is independent, efficient, accessible, and responsive to the aspirations of Kenyans and a true guardian of the rule of law. I put the objectives there, which I have discussed at length when I was answering questions, key objectives and deliverables, what I would do in financial management and support the independence of the judiciary, what I would do to build partnerships and enhance synergies in coordination, especially the NCAJ, which I see the collaborating body that brings all the stakeholders in the administration of justice to sharpen their skills in their service delivery, because justice is like a chain link. It is weakest at the weak point and it is strongest at the strong point. So it has to hold together, pull together, so that we can all stand to defend the rule of law. So this is the write-up. It doesn't need, it's a submission, because I used to be a good lawyer when I practiced law.
And we assume, Judge, that a lot of those things, you have talked about them already.
They are all spoken.
But you have accepted the document. Thank you very much.
Yes,
do you have any question for us?
Not really, but to thank you most profusely. You have treated me kindly. You have done a thorough job. I've watched the other interviews. I think this is the most patient panel that has sat so long. I've appeared before, and it was, within an hour or two you are finished. So I think you are thorough in the way you have done your job. I wish you all the best. In fact, all of you are new to me as commissioners, except my brother, Justice Wasame, who I have met before in these panels. So I wish you also Godspeed as you search for the Chief Justice of this great republic. God bless you.
God bless you too. Thank you very much, Honorable Judge. We wish you all the best too.